Five.
All right, welcome back to the House Judiciary Committee this Thursday afternoon, April 2nd. And we're wrapping up, I believe, our testimony on 181. Saving the best for last, of course. And thank you for being here.
Thanks for having me. I'm Matt Valerio, Defender General. This morning I was in Senate Judiciary talking about guns. And I opened with quoting a famous movie which said, "I think we need a bigger boat," because that room was, well, you know what happens.
Yeah.
Not the same this afternoon. Not at all. Maybe you could trade boats. In any event, S-181, the deferred sentence bill, which eliminates the absolute requirement of a pre-sentence investigation. And I believe that Judge Zone probably presented an addition that said, that amendment or addition is, in my opinion, it's existing law. A judge can always order a pre-sentence investigation whenever the judge wants to do it. There's nothing in law that prevents that, and they do on occasion. Here's the history part. For my entire practice career, and I said this before, but for the record, my entire practice career from the late 80s until I became Defender General, deferred sentences did not require that a PSI be part of the resolution at all. Around when I became Defender General, there was a push to allow the defense to ask for a deferred sentence over the objection of the state's attorney. And we were arguing about that for 2, 3, 4 years, maybe 5. The first that I was DG. And ultimately it got to the point where that was going to pass. And as sort of throwing a bone to the state's attorneys who didn't want that to happen, they were arguing at the time that defense would file these in every single case. And if they didn't, they wouldn't be doing the right thing. And, I was basically saying we only file it when it's appropriate, just like every other motion that there is, motions to dismiss, motions to suppress, or whatever. But as a bone to them, they said, all right, well, if you don't, we're going to end up passing this, but we'll put in a provision that says PSI is going to be required and it was particularly to deal with, it covered all of them, but to deal with deferred sentences that were over the objection of the state's attorney, so that, managing the risk thing. There was never a requirement for decades and decades before that, but that's how it came about. Over a period of time, being flooded with motions for deferred sentence over the objection of the state's attorneys didn't happen that way. They happen as you would expect they would happen, where there's an appropriate case. The state doesn't agree with the defense, and so they file it and make a judge decide. For context, and I don't want to belabor things if everybody else has talked about this, but deferred sentences come up in like interesting ways that diversion doesn't come up. One of the ways it comes up is in cases where the state has a lot of difficulty proving its case. So it might be a serious charge, but you might have a complaining witness who has recanted their testimony, so it didn't happen. You might have a victim or witness who has changed their testimony, or who is not available, or refuses to show up. And as a result, the state knows, and the defense also knows, to like 99%, that state can't prove their case. So the offer will come that, well, can we do a deferred sentence, put the person on probation for a period of time? And if the person satisfies their conditions of probation for the deferred sentence, then the case will be expunged, but at least we have kind of eyes on him or her for a period of time until that deferred sentence runs out. So that's one of the ways it arises. Another way it arises is where the defendant absolutely denies that anything happened, and or no crime was committed, and there's big risk. Maybe it's a sexual assault, or maybe it's a aggravated domestic assault or something like that, and the defendant absolutely denies that anything criminal occurred. The state's case is wishy-washy, but you get the defendant to do a risk management sort of situation about their own life, and they say, well, and these things kind of come together very quickly. You bring them a deferred sentence offer and say, look, if you can do this, this will get expunged. You can always answer this never happened as a matter of law, and we'll have a plea agreement. The thing about those particular types of ones, particularly, is that the time to make the deal is when you get that defendant in the headspace of, I'm willing to accept this. You don't want to come back 3 months later, 6 months later, after a PSI is developed, and the defendant is like, no, screw it, I didn't do anything. I'm not going to take this deal. So now they're walking. And this sounds like, well, that's fine. They should go to trial then. It's not really the way the system works. When you get all the parties together where everybody's head is in the right spot, this person is mitigating their risk of what might occur if they're convicted of serious charge, and they're willing to accept a no contest plea to a deferred sentence, and the time to do the deal is right then. The pre-sentence investigations interfere with the resolution of those cases, and it puts victims in a bad spot, puts the state in a bad spot, puts the defense counsel in a bad spot. The court gets angry because the defendant, said they were going to do something. Now, 3 months later, now they aren't going to take the deal. They're going to withdraw their plea because there has been no sentence imposed, because it's a deferred sentence, because it's not. So there's no sentence. You have the right to do that. The requirement of the PSI kind of interfered with the resolution of cases that could and should be resolved for all involved. Now, I always say that people, kind of lay people looking at it from the outside, might look at these cases and go, what's wrong with that? There are these kind of balances that go on in the criminal justice system when you peel back the layers of the onion, and you're like, ooh, that stinks. That doesn't look right. When you come into plea agreements, nothing looks right. You're not negotiating like you would in a personal injury case. I'll take $100,000, I'll take $50,000. We'll meet in the middle and it'll be $75,000. When you're talking about sentences and years in jail and things like that, this is an impediment to resolving cases that need to be resolved. And I think all of the practitioners over a period of time have come to see that. Now, there's some who may not like it. I'm sure there are, prosecutors who feel that this would be problematic. They're giving up ground that they gained at the time that the original bill was passed that added the PSI in there. And I could see how they would feel that way if you're thinking it as a, kind of a zero-sum game where now I've lost something and now I'm getting it back. To me, this was just, I know the way it came up and I know why it was developed. There was not a complaint really about this before it came in, but this was part of a deal legislatively, so that people were more felt better about making sure it worked. And what this does is goes back to the old way of doing things, except for listed crimes, which is current law. And before there wasn't even that requirement. There was nothing. But the amendment that was suggested by Judge Zone that was run through all of us before the day started, actually started last night, kind of later, is fine. It doesn't change existing law. This does change existing law, but I think it's something that makes the administration of the justice system quicker. It also accommodates particular types of cases that are often very difficult to resolve. And I just have in mind kind of nasty case, the sex case that I did in Rutland at one time. And there were two co-defendants, and there was a prostitution situation, and the prostitute alleged a non-consensual sex act, and the people were charged with like kidnapping and unlawful restraint and aggravated sexual assault and whatever. And I remember my particular client was like, I didn't do anything. I did absolutely nothing. And I said, well, you're looking at multiple life in prison possibilities here. In the event, now you have a good case to try, which means like maybe you have a 60-40 chance of winning. That's a good case to try from a defense standpoint. But you have a 40% chance of being convicted, and you have 2 life sentences you're looking at. I have an offer from the state where it's a deferred sentence. And my client, I remember this so clearly, he says, I'm not admitting any. And I'm like, okay, well, we can do a no contest plea, and we can do a no contest plea to what's called an Alford plea. And what that means is I'm not contesting that the state might be able to prove its case beyond a reasonable doubt. If we went to trial, that's the no contest part. The Alford plea is, and I'm only taking the deal because the deal is too good to pass up. That's what an Alford plea is about, and for those who don't work in this area. And the client's like, okay, as long as I don't have to admit anything, I'm willing to do this and take my deferred sentence. And I think at that time, they wanted a 5-year deferred, which the guy took. The deal went through, and it would have been a very nasty, unfortunate case to have to try. And the guy had significant potential exposure in a case like that. That was done without a PSI, and it avoided a lot of problems for everybody involved. And so that's not every case is like that. I'm just giving you like an example of cases where this is exactly what something like this would be designed for. And that's what ended up happening. The world didn't fall apart when the defense got the ability to ask for deferred sentences over the objection of the state's attorney, and it didn't fall apart for the defense because PSIs were required in every case. But I think that after a period of years now, we've gotten back to the point where we understand that there's a certain benefit to being able to have the default be, we don't need to do this, but the court can always order a PSI whenever they want. So, I do support the bill, and to me, it's not totally back to the way it used to be, but it's, it's fine, and there are good reasons for it. And I think that while you're going to have some state's attorneys who would disagree, and there are others who would look at it and say, yeah, I remember those days, and it was fine, or I see the wisdom of it. And I don't pretend to speak for them or all of them or any of, for that matter. But it seems like it's good policy and a good way to kind of go back to something that worked before and provides a benefit to the system as a whole. And so, that's why I'm fine with it. I'm obviously fine with the amendment that just makes clear, I guess, that the court can ask for a PSI pretty much in any case they want to. I don't think there was any prohibition on it. So, and I would have expected if a court wanted to, they were going to do it anyway. So basically it's fine with me.
No, that was very helpful to understand those scenarios that deferred sentences work, and especially where a PSI can kind of hold things
Yeah.
up. So,
Derail settlements sometimes.
yeah.
Did you make it through as deferred?
He did. The co-defendant did not get the same deal and had some other issues. So, if you in baseball, if you bat 500, you're in the Hall of Fame. That's what I.
You bet over 300 here.
Yeah, absolutely. 3 out of 10. Yeah.
We were just talking about this a little bit offline before you came in. What typically, why does it take so long to get a PSI?
They're pretty, a true PSI is pretty involved. It's like a background check with various factors that DOC looks at. I think now it's actually taking longer than it has in the past, and it's a staffing issue. What are they? I'm hearing 3 to 6 months.
3 months. The last one that we did, it took 3 months to get it.
Yeah, and if they're more involved, if it's a more serious case, it could be 6 months, and it's just they are pretty involved. Typically, they are used in the most serious cases where there's a contested sentencing, and there's a staffing issue, and that's really the big problem.
Yeah, it feels like I'm trying to not opposed to it, but again, it feels like we're not getting to the root of an issue. Like if one of the reasons to get rid of them in these cases is because they take too long, shouldn't we be addressing why they take so long? But
yeah, I mean, I would agree with that if in the ones that like, could we get one done in a week kind of thing? The ones where you got the defendant in the courtroom, you got the state in the courtroom, we've all come to an agreement, and now is the time to make a deal. PSI, if you could get it done in 2 days, it might not be
right.
ready. And those are not as infrequent as you would think. I think that happens, when people,
Yeah.
they just disagree.
That makes sense. And in that case, you wouldn't be able to, there's nothing in existing statute that would say the parties in the court could agree to waive.
Not under the current law.
Right.
And it also, yeah.
And another scenario could be that the plea agreement would result in someone getting out of jail, and that waiting on the PSI is delaying.
Yeah. So, you get now you get an expungement opportunity, and you've been held because of these big cases, you're being held for God knows how long until you can get to this point. And they're like, you get to walk out today. You have an expungable offense, and you might not even have to go to number 3, and you don't have to necessarily admit anything. You get those things. There's a lot of incentive there, and this, and you also these don't happen typically if the state has a rock solid case. These come up when the state also has like the exposure potential that this person will go to trial. This person walks and there's nobody looking over his shoulder or her shoulder, and they don't have the eyes of probation or the requirements of probation.
And what do you say to the criticism that this change will actually reduce the ability or opportunity for the victim for a victim or victims to be involved in the process or in the outcome, influence the outcome?
Well, one of the reasons these tend to come up is because there's issues with the victim as a matter of evidence. They still have the same right to comment on the plea agreement as they would in any case. And my guess is that the state's attorneys are taking all of that into account before they make a deal. They know the strength or weakness of their primary witness in victim-oriented cases. These also come up in like non-victim oriented cases, unlawful trespasses and burglaries and, that kind of thing where, there's not a crime against a person per se. And they're factual issues. They're not all sexual assaults and domestics, So I don't think that it really changes the ability to have input. What it does is it eliminates the requirement that they testify in front of a jury and go through the unfortunate reality of what happens in a trial.
Any other questions for me? No, I think we're good.
All right.
Thank you so much for coming over.
Yeah, no problem.
All right, so that's our last witness, but just for everybody's heads up in case you want to study by tomorrow morning. So after the floor, I've scheduled for committee discussion and possible vote. S-179, which is the act relating to the Uniform Disclaimer of Property Interests Act. That one is going to go to Ways and Means after it comes out of here. S-183, an act relating to home improvement and land improvement fraud. At this point, we would be passing it and going right to the governor. I don't think there's any amendment on that. S-203, the act relating to penalties for second or subsequent violations of operating a motor vehicle under the influence of alcohol or drugs. We still need to talk about that because I'm not sure that everybody's in the same place with that one, but possible vote. And there is one minor amendment, so that would be going back to the Senate if we vote out. And then I think what we just did, S-181, which also has an amendment and would be going back to the Senate. But we'll have a discussion and possible vote on all four of those. Kind of clear the deck before we look at forensic 208 and 209 and Prop 4.